Angie, thank you.
Thank you.
Okay. Tell the students a little bit about what led you to law school, and then in particular, what led you to do what you do.
It will be very corny and very cheesy, but it is the truth. When I was in the 8th grade, back in my day we called that junior high school. I know most of you probably refer to it as middle school. We had a class called Youth in Law, and it was all about the juvenile justice system. And so we had all kinds of great projects and cool things to do, building little juvenile detention centers out of popsicle sticks and things along those lines.
Really?
Really. My dad helped me craft it. It was great. You know, we had the shower and the cafeteria and the yard. It was very fun. But it wouldn't have been fun to be there. The other thing that was fun was we had a mock trial. And in the mock trial, one of our classmates was accused of going down to the creek with another classmate and stabbing her. And I got to be the defense attorney in that case. And I don't know why I wanted to do it. I just wanted to do it. But once I had participated in that, my fate was sealed. I knew from that moment, 8th grade, I knew I wanted to be a defense lawyer. Now, I didn't know then what was a public defender. I don't think I had any sense of public defender, but I knew I wanted to represent the underdog. I knew I wanted to represent the person that needed good, quality, effective assistance without having to pay tons of money for it.
A lot of us never recovered from 8th grade, but at least you turned it to something positive.
I did. I got it in my mind. I went straight through undergrad, straight to law school, started at the public defender's office in my 3rd year of law school, and I've been there ever since.
Well, talk to us a little bit about what it means. Describe your job to us and tell us about your clients, how they end up being one of your clients, and the kinds of things that they're accused of doing.
We represent people from every one end of the spectrum to the other, from shoplifting to murder. Now, we no longer handle death penalty cases because Georgia established the capital defender system, and I'm thankful for that. Death penalty cases take a lot of time. They take a lot out of you. I handled a couple before the capital defender system came into existence, and it's excruciatingly painful and difficult, as is any case. But that's, you know, the ultimate punishment, and it can be very trying if you think you have a person who's going to lose their life at the hands of a jury. Unfortunately, none of our clients ever did. I handled 2 death penalty cases during my time, and I take that back, 3 death penalties, and each of them ended up with life sentences. So I was very grateful for that. When you ask what kind of people do we represent people like you, or your sister, or your dad, or your aunt. We're just people who find themselves in situations where they are facing prosecution by the state, and they need somebody to stand in the gap.
The latest statistics I've seen are that in Georgia, about 80% of the criminal defendants are indigent and need somebody like you.
I would think that's right. We actually do not keep up with the statistics. We have an indigent defense coordinator who is responsible for determining whether somebody qualifies for the public defender's office. And it's very simple. It's based on the federal poverty guidelines. So if one person makes X number of dollars, they qualify. If they make over X number of dollars, they do not qualify, and you deduct for each dependent the person has and whether they have child support payments and things along those lines.
Well, you're a very experienced defense lawyer. Now, you told me just before we started that you have 180 cases open at one time? On
average. We have 8 felony attorneys or 8 attorneys in the felony division and 3 attorneys in our misdemeanor division, and on average we carry between 180 to 200 cases at any given time. And state court carries far more than that because they have a greater turnaround.
I didn't warn you I was going to ask this, but I've got to ask this. With 180 files, can you do it the way you want to do it?
Oh, yes. I do it exactly the way I want to do it. I do it exactly.
with that caseload?
When I first started in the public defender's office back in 1989, we had 3 attorneys, and we each carried a caseload of about 300. So you learn how to manage time, you learn how to prioritize. And the truth of the matter is all those cases are not going to come up at once. I've been doing this since 1989. I was telling Pat earlier, our backlog in Houston County has actually decreased here lately, and I think that's due in large part to our judges finally taking control of the trial calendar and finally prioritizing cases by age as opposed to nature of offense. A lot of times, oh yeah, a person charged with armed robbery, they need to be up first versus the case that's 3 years old. So they've switched it around, and so now our backlog has decreased. But back to your question, I've moved away from it. You learn how to manage, and like I say, not all those cases are going to come up at once. I have had situations where I have been overwhelmed and felt like I wasn't going to be able to effectively represent my client. And the one time I can remember specifically going to a judge about it, I had 22 cases set for motions. Now, I file motions, and I argue motions. I had 22 cases on one motions calendar, and I went to Judge Lukemeyer and I said, look, I'm good, but I'm not that good. There's just no way I can handle 22. And he was very gracious, and we sat down and went through the calendar, and we went through those cases that were older. And so he selected the older cases to force the DA's office into, making some decision. Let's fish or cut bait here. And I think I ended up with maybe 14 on the motions calendar instead of 22, but I handled that just fine.
Your clients didn't pick you. You're appointed.
That's correct.
To represent them. Do you find it difficult to build trust with your clients?
It depends on the circumstance. One great thing about our office, and I wish more public defenders' offices would do this, and I'm not sure, I don't know how others operate completely, but we have consistency in representation. I've been representing some of the same clients since 1989. I've grown up with them, they've grown up with me.
Repeat customers?
Yes, because it's like getting married. Once you're assigned to a public defender, till death do you part. At least in our office, we like the continuity of representation. So, for example, you come in charged with a shoplifting this week, you get assigned to me, I'm your attorney throughout that. You come back 2 years from now, or 6 months from now, charged with violating your probation, I'm your lawyer. And that really helps in building a level of trust. And I just treat people the way I would want to be treated. I want your respect, so I'm going to give you respect. The media gives us a bad rap, books give us a bad rap, movies give us a bad rap, but the truth of the matter is we're the ones in the trenches, and we're the ones who know what we're doing, and we fight really hard for our clients.
But I would think, and what do I know, right? But I would think that the first time you did something, they would look at you and think, who's paying her? The same people that are paying the one that's prosecuting me. Whose side is she on?
That is a common misconception.
Good.
It is a common misconception, and you will have clients who will say, you're getting your check out of the same window. You go to the same window to pick up your paycheck. It's not true. The state pays for the district attorneys. We are county funded. And I'm very proud of Houston County because Houston County was far ahead of the curve here in Georgia. We've had a public defender's office in Houston County since 1974. And our county commissioners are very supportive of our office, and they understand what a difference we make, how much money we save the county every year. So they've always been very financially supportive and just supportive in general. You just have to work through that with a client. You just have to prove to them, and it's no greater effort. It's not as if you come back every day and say, I didn't get paid by the state today. You just show them in your actions and your demeanor and how you treat them and how you are prepared for court. I mean, there's no better way to prove to a client that you mean what you say than to be prepared and ready when you go to court.
Now, I'm not sure the students would appreciate the historical context here for the Houston County Public Defender's Office, because the public defender system statewide went into effect, what, about 10 years ago?
Yes, actually about 12 years ago
12 years
now.
ago.
There was been just, I don't know if you guys read the newspapers or pay attention, but just a week ago, there was a bill that got tacked on to part of Governor Deal's criminal justice reform bill, and it was about to undo all that was done 12 years ago to give consistent representation throughout the state of Georgia. Way back in the day, Georgia did not have a statewide public defender system. We had just a hodgepodge of indigent defense. You had some counties that did contracts, you had some counties that did panels, you had some counties that had public defenders' offices, and so people were getting a very disjointed sense of representation. There was no way to really have standards and to have guidance for people who were representing the poorest people who needed the best representation. There's no way to keep an eye on that. And so Justice Norman Fletcher commissioned the Blue Ribbon Panel to study criminal or indigent defense throughout Georgia and to come up with a plan for what we needed to do to make it better. And ultimately the decision was made to create a statewide public defender's office, statewide public defender system, so that in every circuit in which there was a DA's office, there was a public defender's office. Because fair is fair and equal is equal. We are an opt-out county from the statewide system.
But you were already,
well,
you were already there.
Our office was actually the model office. We were the office on which the plan was based, because not my predecessor, but my mentor, Terry Everett, who was the public defender from, let's see, I guess 89 until 2007, did an amazing job. We had a great public defender's office that was always dedicated, always efficient, but she really, really brought us up to the level where we are now. And Mick White has just continued to maintain that level.
Well, help the students understand what it's like to be you. Is there a typical...
It's awesome.
That's what I meant. Is there a typical week, a typical day, a typical month that you can describe?
Yes. One thing about Houston County is we are a one-county circuit. Many public defenders' offices have several counties within their circuit, and so they have to travel in what we call ride circuit. They have to go from one place to the next. And Cordele has been in the news a lot because their public defender's office has been sued by the Southern Center for Human Rights because they still are underfunded, they still are understaffed, and people are not getting the representation they deserve, and to which they are guaranteed under our Constitution. But in Houston County, we get our year-long calendar about midway. Well, for example, we'll get 2016's calendar in about the middle of the summer of 2015.
You go up to your second. I'm getting some feedback back here. Is that, you all can hear that? I'm going to turn down the master volume for just a little bit, see if I can cure that. Sorry. Yeah, I'll try.
Testing, testing. You don't need a microphone to hear me, I can tell you that. I've learned
Let's do an acapella.
with court reporters through the years, you learn to speak up loudly, clearly.
I'm sorry.
That's quite all right. So typical week in Houston County. On Monday, I get a jail list. It tells me everyone who is in the Houston County Jail from A to Z. It lets us know the nature of the person's charges. It lets us know whether they have bond. It lets us know the date of their arrest. And we go over that jail list every Monday. As I say, our indigent defense coordinator creates a list of who's been arrested over the weekend. And that's a daily thing. We get a jail list every day. Now, we don't get the big jail list every day. We get that on Monday. But Tuesday through Friday, we get another jail list. Prints out, tells us who's been arrested since the night before. Our indigent defense coordinator determines who's been arrested, goes over to the jail, sees them, qualifies. If they qualify, they are immediately seen by our paralegal, interviewed, file comes back to the office, file gets open. We have bond hearings every Thursday morning. We have pleas in association with that. We have probation revocation hearings every other Wednesday and every Thursday afternoon. We have 2 trial weeks every month, and thus we have motion hearings once every month. We have arraignments once every month. It's very organized. That is a huge benefit to Houston County. Is it is very organized, very efficient. The judges are involved, and we stay on top of things.
When I envision you at work, I envision you in a very dramatic jury trial, right? And that's what public defenders do in my mind. But you've told me that's not true. I mean, how many cases do you try in a year?
I don't keep stats. It's just not my thing. I was telling Pat earlier, I went one time 18 months without trying a case. It's just, and that's hard to believe in a public defender's office. That doesn't mean my coworkers weren't trying cases, but I personally have gone up to 18 months without trying a case. And sometimes I just can't get a case to try. I filed 2 demands the last trial term. 2 trial demands, I was ready, let's go. And the DA's offered misdemeanors on both of the cases. Felony burglary, down to misdemeanor criminal trespass, felony fleeing, down to misdemeanor fleeing or speeding, I can't remember. It's a misdemeanor with time served, so everybody was happy.
Except you wanted to try.
I love trying cases. I absolutely love trying cases, but there's always a risk involved. And at the end of the day, if the client is found guilty, he or she may be the one going to prison, not me. So if it can be resolved and the client's happy with the resolution, then hey, I'm happy to go 18 months without trying a case.
Well,
I get plenty of courtroom experience though, because as I mentioned earlier, probation revocations are little mini trials, and those, I can't even count how many probation revocation hearings I've had.
Well, you love going to trial. Tell us more about what it is you love about your job.
I love my clients. I just...
Are they all lovable?
Yeah. After they meet me, they are. I just have an affinity for this kind of work. It's all I've ever wanted to do. I've never thought about doing anything else, and I know people probably think that's hard to believe after as many years as I've done it, but I love it. I love what I do. I love taking care of somebody. I love guiding them. I love standing in the gap. I believe in the Constitution. I believe in the rights it guarantees. Where's my flag? I believe, I can't put it into words. I just love what I do.
How do you not burn out living like that?
You do. You do burn out. And you take a week's vacation and you go to the beach. Or one big thing that I have is the Georgia Association of Criminal Defense Lawyers. I am the executive vice president right now in line to be president, but I've been a member of that organization since I started practicing law. And it is an amazing group of people. It's people who do what I do. It's people who experience what I experience every day. We are the largest member-run organization in the country. I think we have anywhere from 1,600 to 2,000 active members. So that's people who are doing criminal defense, who want to be a part of a group that helps support you, helps train you, helps teach you, and comfort you, and give you solace, and laugh with you when things are funny, and cry with you when you've had a bad day. I can reach out to any one of those people. And then on top of that, my office is made up of an amazing group of people. We're like family, and we have the benefit of being a smaller office. We're all in one office, and we don't have a whole lot of turnover because we have such a good group and people are really committed to what they do. I've been there 26 years. Cindy, our office manager, has been there 24. Claudia Meyer has been there 12 or 13 years. Nick's been there since 2007. We just mesh really well, and we take care of each other.
What's the hardest thing about your job?
When a client goes to prison, even if that's where they're supposed to be.
I know, but what does that feel like? I mean,
it hurts. It's just devastating. It is, so many people don't, you got to think of all the other consequences. It's not just somebody going to prison, it's their child being without a mother, or their husband being without their wife. They lose their job, they lose their home, they lose connection to the community. It's just sad. And it happens, and it rightfully happens, but it still is very painful.
It's hard for me to imagine how that feels. I mean, you're standing there, they're convicted, and they're led away. I mean, right then. I mean,
I cry a lot. I had a client, and it's, you know, even if the state proves the case, you still hurt. I go to trial on cases where I believe my clients are going to be convicted because they want to go to trial. There's no offer. The offer's horrible, whatever the case may be. But I had a gentleman who was convicted of an aggravated child molestation, and he got 25 without parole. Now, 25 without parole. No prior felony convictions. 40-some-odd years old. The alleged victim was 15. And he's serving 25 without parole. And it breaks my heart. That's not right. It's not fair. It's not just. Those types of sentences are draconian, and they have no place in our system. And so when he crosses my mind, I think about what all I've lived in the last 5 years. You know, what have I done in my life in the last 5 years? He's lived his life in prison, and he's got 20 more to go.
how do you get past that?
You don't. I think it's pretty obvious that I'm not past it because I'm about to cry right in front of you guys. You just have to take a deep breath and take your next step and just hope that they're doing okay.
Well, obviously, you represented people accused of child molestation. You represented people accused of murder, kidnapping, burglary, aggravated assault, and I could go on down the list.
I will tell you this, a repeat shoplifter is the most hated client in the world. I hate a repeat shoplifter.
All right, I'll bite. Why?
Because they're whiny. They're the whiniest clients. And in Georgia, if you're a repeat shoplifter on your fourth, you have to get a year in prison. Right? A year in prison. You're supposed to get a year in prison for shoplifting a hairbrush. But that's what the law says. After 3, your next one's a felony. No matter the amount of the property, no matter what it is, it's a felony. And the statute says you get 10 years to serve 1. So try explaining to somebody who's stolen a hairbrush that they have to get a year in prison when you've got somebody who's charged with, stabbing you 5 times, and they may get probation.
I was whining too. Well, here's my question. You represented, and I assume you represented a number of people who actually did the things that they were accused of.
Sure.
Do you ever get the question, how can you represent such people?
All the time.
All right.
I'm sure several people in here have wanted to ask that very question.
And
just like you would anybody.
Right.
It's not the nature of, you're not defending the crime. You're not saying it's okay to go out and murder someone. You're saying you as the government, you as the state of Georgia are saying that you did something, you better be able to prove it. Bring it, don't sing it. That's why it's easy.
But you're very good at what you do, and so I assume that you've obtained acquittals or gotten evidence suppressed that allowed people who had done terrible things to walk free.
I haven't had a murder case dismissed yet because of a motion to suppress, but I've had several drug cases. Again, this is not moral court, people. It's legal court. If you believe in any kind of greater judgment, that's going to happen some other day. This is legal court. I had an assistant DA who is now a state court judge, who would just on a regular basis say to me, your client knows he did it. I don't care. I know he did it too. Prove it. And I would have to say to him, this is not church. This is not moral court. This is a legal courtroom. You bear the burden of proof. Come on, let's go.
Have you ever had somebody that you obtained either a dismissal or an acquittal for who went out and reoffended?
Every day. We have a lot of repeat business, and this is one thing that is very, you talk about burnout, this is one of the things that's very tough, because in my line of work, if a client successfully completes his or her probation, I never see them again. So the success stories are kind of out of sight, out of mind. What I deal with, unfortunately, is about 15 to 20% of clients who, for whatever reason, just can't make it. They fail to report, they get a new offense, they're addicted to drugs, so they're going to be repeat offenders. That becomes a little discouraging, because you obviously focus on what you see as opposed to what you don't see. But the statistics are there. The majority of people who are placed on probation complete their sentence successfully, and they never get in another day's trouble. And I never hear from them or see them again. Occasionally, clients will come back and let me know how they're doing and that they have successfully completed their time and things are going well for them. I remember one young man in particular, he was charged with trafficking drugs. We ended up working it out, the possession with intent, but he did have to go to prison. But he went away under the first offender statute because he'd never been in any trouble before. He successfully completed his prison time. He successfully completed his probation, started his own business, became a pastor, and he came back to let me know that he had accomplished all those things. I still have his card. And those are few and far between, because I think most people, when they get past it, don't want to revisit it. So it's not as if they want to come back to my office and tell me all about how well they've done. They get through it, and it's in the past, and it's done.
But you say those are few and far between.
Well, the success stories are many.
Right.
My knowledge of the success stories is few and far between.
Well, then tell me generally, as a defense lawyer, how do you define success? And it can't be dramatic acquittals and jury trials. I mean, what does success mean for you, for a client?
Doing my best for the client. I mean, truly, there's been times when I felt like I dropped the ball somewhere, and you don't feel like a success in those moments. You don't feel like a success when you have 22 sets of motions to be heard, and you fear that client number 7 is going to suffer over client number 10. That's hard to handle. But like I say, the more you practice, the more you do, the more successful you become at prioritizing and being able to give client 7 and client 10 everything they deserve. Creating that trust with the client, standing up to judges and DAs, and just giving it your all.
In past years, I haven't done this with this group, but in past years I have asked the students, in a forum that's private, so nobody sees it but me, if there's any kind of client they could not represent. And almost uniformly, the answer I get is somebody accused of child molestation. You've represented a lot of people accused of child molestation. Is there any kind of person you wouldn't be able to represent?
No, because again, you're not defending the allegation. You're not saying it's okay to molest a child. You're saying, if you, as the state of Georgia, think this happened, you better be able to prove it. And I've had a number of child molestation cases where my client was innocent.
But you've had a number where they were guilty.
Of course. And if the state can prove it, then the system works the way it should. If the state can't prove it, System works the way it should.
Are there particular cases you can think back on in your career that taught you particular lessons that really stand out in your mind? I mean, there's been so many.
Yeah. In combination with advice from a friend, there was one case that helped me to realize that I need to just let my client be my client. We all teach our children, don't judge somebody based on the way they look, right? Don't judge somebody based on the way they look. Judge them based on the content of their character, get to know them, how they dress, the way they wear their hair, all that really shouldn't matter to you. You should get to know them as a person. Well, when you're a defense attorney, or I guess any attorney, you talk to your client about presentation. Going to court, you might need to cover up that tattoo. We're going to court, you might need to take the braids out of your hair. And I had a particular young man, Maurice Collier was his name, he's deceased now, but I remember him. This is way back when we were in the old courthouse, this is probably early 90s. He was African-American man, had dreads, little tiny dreads, and he was charged with stealing his own car from the police impound lot, which was hilarious to me. And I didn't do it. Angie, I didn't do it. I said, I'm good, Maurice, let's go. So we're prepping for trial, and I'm telling him, you may want to think about cutting your hair. You may want to think about it. You know, people, they shouldn't do it, Maurice, but people judge based on how you look. People judge based on how you dress. Hair's a little different. You may want, I'm not cutting my hair. I said, I'm fine. If you don't want to do it, don't do it. But just understand what I'm trying to tell you. So we go to trial on this theft of his own car. We have an all-white jury. And within an hour, they were back with an acquittal. And that moment, in combination with, like I said, what a good friend taught me was, let your client have the dignity of being themselves. Right? If a jury's going to convict somebody because they have dreadlocks, then that's on them. But let your client, don't try to change them or make them be something they're not. Let them have the dignity of being themselves.
And yet you gave him the advice, and he could accept it or reject it. But you gave him the advice that it could have affected.
It could have, but I don't give that advice anymore. No, because that moment representing Maurice and the friend of mine is Cynthia Roseberry. You know Cynthia. She was the federal public defender here in Macon, and now she's working with the Federal Clemency Project. She's appointed by Barack Obama to be the director of the Federal Clemency Project, and she talks a lot about isms and schisms and problems that we have in the system with just that, judging somebody based on how they look as opposed to the evidence the state brings.
You see people once they're in the system, but getting to know them, I'm sure you learn about why they're in the system. What is it in the communities that you serve that causes people to end up in the criminal justice system?
Oh, well, I mean, there's a common drugs. Some people are just thieves. I'm just being honest. Some people just have a compulsion and they just can't seem to help themselves. Circumstances. It just, I don't have an explanation for that.
Poverty.
Other than the general explanation. Poverty, drug addiction. You get in a fight with your best friend and you punch him in the face, and then all of a sudden you're charged with crime and you're coming to jail.
For years, I invited you, when I was in charge of the counseling course, to come and demonstrate to the class how you counsel a client on a plea bargain. How do you handle that? I mean, if you get an offer that you think is good, do you tell your client what they should do?
No.
But they're going to ask you, what should I do? How do you handle it?
And I tell them you have to do what you think is best for you. I can't tell you to take this offer. I can tell you that I think it's a good offer. I can tell you that I think it's a terrific offer. But ultimately, you have to decide whether it's an offer you want to accept. We can counteroffer. We can try to even get a better deal than what's on the table. I tell clients, look, a trial is a risk. It's always a risk. It's 50-50, it's a roll of the dice, a toss of the coin, whatever you want to call it. The majority of the time, a trial is a risk. You may walk out the victor, you may walk out in chains.
Wow. I mean, but surely you get clients that say, Angie, I'm torn, tell me what to do.
Yes, of course. They say, tell me, what would you do? What would you do if it were you? And I say, I can't speak to that. It's not me. That's really a place where you cannot put yourself in that person's shoes because it's not you. You don't know all that's coming into play. You don't know what all is affecting that decision. It's not me. So I can't tell you what I would do because that's not fair.
The other big counseling moment that I see or foresee in your job is the defendant who wants to testify. Now, I imagine you've got a lot of clients who want to testify who probably shouldn't, right?
Yes.
How do you talk them down?
Just patiently go over all the advantages and disadvantages of testifying. I remember a particular case, the client was charged with armed robbery. And he wanted to take the stand, and ultimately, had he insisted, I would have let him take the stand.
It's his right.
Of course. His absolute right. There's a lot of decisions that the attorney makes that are the attorney's to make. Strategy, what witnesses to call, what kind of defense to put forth, what charges you want the judge to give. I try to involve my client in every aspect of the case because it's not my case, it's their case. So I try to involve them in every aspect. You know, do we want to ask for a lesser included or do you want all or nothing? Even that I discuss with the client. And testifying in this particular case, I told him, I said, look, there's no reason for you to take the stand. You've said you're not guilty by going to trial. There's nothing you can add to the testimony that's already been provided. All you can get up there to do is say, I didn't do it. And we've already told the jury, you didn't do it. He ultimately decided not to testify. Thankfully, he was acquitted. So there was no
Ever had one that made the other choice and lived to regret it?
I can't know if they lived to regret it. We had a murder trial one time, and prepped our guy, and he did great. One of the things that we had discussed was you don't ever call anybody a liar, and you just don't. They may be lying, but you don't call them a liar. So we're in the middle of this axe murder trial with a surviving victim, by the way, who identified our client.
Strike one.
Yeah. But it was necessary, it really was necessary in this case for him to testify. Great job, did a great job on the wreck, he's doing a great job through cross. The DA starts asking him about why people were saying things in contradiction to what he had said. And we had talked about this, the people that the DA was, to whom the DA was referring were our clients' friends and our witnesses. And I think they were, like this witness said X and this witness said Y. It wasn't that great of a disparity, but it was enough that the DA starts crossing our client about it. And I can remember these, in the chairs were like little swivel chairs in the witness box. And so the DA is questioning about, well, Mr. Smith, why is it that so-and-so said that and so-and-so said this? And I can, I swear I remember sitting in the courtroom and watching him. You know, you get your breath, you're holding your breath, and he kind of leans back in his chair, and I'm thinking, it's good, he's going to say something. He leans back, and then he rocks forward and he says, I don't know, except that they're lying. No, actually, the jury was out. This was literally a case where the surviving victim identified our client as the one who had axed her in the head. The jury was out for over 8 hours on guilt, innocence, and ultimately did convict him. But yeah, that was a rough moment. I can't think of any reason except that they're lying.
Exactly what you told me not to.
Yeah.
I'm going to turn this over to students in just a minute if there's any questions that they have, but I always give our guests a chance to say anything you think they need to hear. Anything, any advice, anything, maybe something you wish you had heard when you were a first-year law student. What advice do you have for the students?
One piece of advice I would give to you, this is going to sound silly, but please do your best to take the word like out of your vocabulary. I don't know what it is about young people, if you will, but the word like is so overused. Please take it out of your vocabulary. That's one thing. We're public speakers. Don't say you know. Don't say I mean. Don't start your sentence with or And please, please restrict the use of the word like in your conversations. As far as actual advice about where you're going, just know your heart. Know your heart. Know what you want to do with this law degree. Commit to that. If you go into defense work, commit to that. Commit to the ideas. Commit to the belief. Commit to what it is you're doing for other people.
And if they want to do what you do, they should come work for you under the Third Year Practice Act.
Indeed. We will put you to work under the Third Year Practice Act. I was telling Pat earlier, we've got several third-year students who are working with us now, and they've done everything from probation revocation hearings to motions to suppress to sitting second chair. Andrew Fagan is a third-year student here, and he recently assisted on a burglary case. And he did the opening statement, he crossed one of the officers, and that case ended in an acquittal. Yeah.
That's a good thing.
That's a good start.
All right, let me turn this over to the students for
Sure.
a few minutes. What questions do you have for Angie this morning?
You mentioned that you get a lot of repeat business, if you will. How do you handle the clients that weren't exactly happy with your representation of them, and now you've got to represent them again? That's
a very good question, and I do not say this to toot my own horn, but I've been there so long. I have a very good reputation, and it's a rare occasion that I have somebody that's unhappy with me, because you get to know the person as a person through the repeated representations. But we do have those situations where clients come back after having entered a plea of guilty, they're back on a probation violation, and they will write a letter that says, I want anybody but Angie Coggins. Anybody but Angie Coggins. Well, that's not the way it works. You're entitled to appointed representation, but you're not entitled to the appointed attorney of your choice. You get who you get. And with our office, again, it's the continuity. So if I represent you this week, I'm going to represent you next week. We just have to work through whatever differences we may have at the moment. And I see it all the time with clients. Because I'm the Chief Assistant Public Defender, all the little complaint letters come to me, and people send the inmate request form, and they say, I don't want Miss Hall, anybody but Miss Hall. Right back, Miss Hall's a fine attorney, she'll represent you effectively and zealously. If there's a real issue, but just because you don't like her doesn't mean she's not going to do a good job for you. And through that, and truly through the continuity of representation, those kinds of issues, like I say, they finally resolve themselves because our clients ultimately see that we do have their best interests at heart, and even if you don't like me, I'm still going to do my best to kick the DA out of the courtroom.
You said that it's about defending the person and not the crime. For something that's a repulsive crime, especially if it was to be a repeat offender, how do you I mean, how do you process that mentally? I don't understand that. Like, if you defended some person that was charged with child molestation and they were acquitted, and they come back as a repeat offender for another child molestation case, like, I mean, I don't know. I'm trying to figure out where you get that strength from to go to do it.
I don't know. I don't know from where it originates, but it's there, and that's a valid point. And you will, like I said, know your heart. If you believe, I go into this job, I can't represent somebody charged with child molestation, then don't represent somebody charged with child molestation. Now, if you're in a public defender's office, you're not going to have much choice. But in private practice, you pick and choose. And if you don't want to represent somebody who's charged with child molestation, tell them to go see Hug and Hogue. You know, just send them to the next person. But it sounds so trite, but it's the truth. The Constitution says you are entitled to effective representation of counsel. It doesn't say you're entitled to effective representation unless you're charged with child molestation, or unless you're charged with murder, or unless you're charged with repeat shoplifting. People make fun of the phrase true believer. I don't know why. We should all be true believers, whether you're prosecution-minded or defense-minded. We should all be true believers in what our Constitution guarantees. It's that simple.
I'm sure you see new attorneys very often. What are some of the common mistakes that they make when they're trying cases, besides saying like?
Being unprepared. You have to know your case. You have to know your case better than anybody in the courtroom. You have to know your case. And you have to, from a defense perspective, and everybody has their own style. Obviously, everybody has their own way. I'm a very client-centered person. I'm very touchy-feely, very emotional, because the person sitting next to me is just that, a person. It's not a number. It's not a charge. It's a person. So I want to do my best for that person, and surefire way to guarantee that is to be prepared. Know your case. Yes, ma'am.
As a public defender, do you, maybe when you were like first starting out, did you ever feel like at a disadvantage being the public defender, going against the prosecutor, and also, you know, with the judge being there as well? Because I guess the stigma that's always attached to individuals who don't have enough resources to get representation. So,
I have felt that on occasion when you have judges that were former prosecutors, and that's all they ever did was prosecute. You tend to feel like there's a little bit of a bent that motions to suppress are going to be considered. You fear that they're going to be pro-prosecution as opposed to pro-defense, or pro-objective, I should say. But the majority of the time, in my circuit at least, I feel like our judges, I know they treat us very fairly. Occasionally I feel like they're helping the prosecution with their job, telling them what questions to ask or what they need to do to get this piece of evidence into evidence. But overall, no, I've never felt that way with judges, DAs, or jurors for that matter. I will tell you this, in all the years that I've tried, in all the cases I've tried, I've only been truly disappointed in one jury's verdict. Conviction, acquittal, when a jury renders their verdict, in most cases I feel like they've done exactly what they were sworn to do. There's no, I shouldn't say there's no better feeling, but it's a great feeling when you've tried a case and the jury has acquitted, and then you speak to the jurors and they say, you know, we thought your guy was guilty, but the state didn't prove it. Because that's the burden. the jurors have listened. They paid attention to what the judge told them. They paid attention to the law. And I found that when jurors come in, just like you guys sitting here, and they have preconceived ideas, and they look at you in the red shirt, and you're sitting next to me at the defense table, and oh, that guy must have done something wrong, or else he wouldn't be here. But once they get in that box, once they get in the box and they take that oath, they really do a good job. And in all the cases I've tried and all the verdicts that have been reached, only one was I disappointed, and it's because we spoke to the jurors afterwards, and it was an alibi defense. One of the jurors said, well, we didn't really think the state proved his guilt, but you didn't prove his innocence either. Well, that to me is a wash. He should have been found not guilty, but they found him guilty because we didn't prove his innocence. So that was a little upsetting, but overall I've been very, very pleased and satisfied with jury's verdicts.
How do you deal with a client that maybe doesn't understand coming in that you're having a good relationship with the state as well as with the judge can really be a benefit to them rather than, you know, what we see on TV, which is that they don't get along, prosecution and defense?
It's just a matter of discussing it with them. If they bring it up, if that ever becomes a topic, you say, look, a good relationship with the DA can sometimes work to your advantage, because if they like me, then in turn they may like you, and we may be able to work out what's charged as a burglary down to a criminal trespass. And you may have only committed a criminal trespass. So it's easier for me to talk to the ADA and say, hey, look, you really don't have the evidence on this case, cut my person a break, do whatever. You just have to walk them through that.
I'm wondering, and this is with my limited knowledge, but I think there are maybe more prosecutors who then become defense attorneys, or maybe vice versa, defense attorneys who then become prosecutors. I'm wondering if you have any opinion about why that happens, or if you know of any colleagues who've done that and why they chose to switch sides.
I know of a number of people who have been in the public defender's office who went to the prosecution, but I can't tell you why. I don't know if it's because they didn't like the work or whether they had a little bit of a pay grade increase when they go to the DA's office. I really don't know, but it kind of equals out. There's plenty of prosecutors who ultimately go into private practice and they do defense work because they've learned it from the inside out, and that's a distinct advantage, I would imagine.
What else?
As a woman, and you're pretty petite, and as you say, you have a heart for the people, so you're kind of touchy-feely. What are some of the challenges that you face when you're dealing with, you know, male offenders or male clients, just person to person, going in and out of, you know, the jails as well? What are some of the challenges, and how do you deal with them?
Again, it just, when you meet the person for the first time, just treat them with respect, just like you would anybody. You meet somebody in an elevator and you say hello and you strike up a conversation, or you sit next to your classmate and you start talking. It's just a matter of trying to establish the same kind of rapport or relationship that you would with anybody. They're no different than you. They're no different than me. Circumstances have placed them somewhere different. Circumstances that may have been beyond their control, circumstances that were well within their control, but it's just another person who needs to just be treated like you would want to be treated. I don't know how to explain it.
Just to carry on just a little bit. I guess what I'm really getting at is, you know, have you dealt with anyone who, you know, took your friendliness a little too far, as far as maybe have, you know, asked you out on a date, or, you know, asked for your phone numbers, you know, something like that.
That's funny you say. I do have one particular client who adores me, and he writes me letters all the time, and tells me that he loves me, and it's the greatest thing that's ever happened to him. And he's right, I am the greatest thing. I take it all in. We go to the jail on a daily basis. and back in the day, we had to drive over to the jail. And we meet, I'm this close to my client when I meet with them. We're not through a glass wall or any partition. I'm right there with you. And I've only had one occasion, literally one occasion in 26 years that, and it could have been a woman, it could have been a man, but in this particular case, it was a man who was very angry and jumped up and leaned over the table, and you just say, I'm done, and you walk out. And you let them calm down and you go back at a later time. You don't have to be disrespected, and you don't have to take any kind of abuse. You just get up and walk out.
Maybe one more.
Sometimes we hear that you're not supposed, you have to take your emotions out of it. Do you agree with, I can answer questions. Do you agree with that?
Yes and no, John Cole.
With a yes and not yes.
Oh, did he change it to yes and not yes? When you say take your emotions out of it, I don't know how I could do this job if I weren't emotionally invested in it. Because while I say I'm not defending the crime, I'm defending there's a person, there's someone's life and liberty and freedom and career and hopes and dreams. So I can't help but be emotionally invested. When you're prepping the case, you know, obviously you can't let yourself be clouded. You can't let your judgment be clouded by your emotional attachment to the client or to their problem or their case. So you learn to separate that, sure, to be able to see the forest for the trees and those kinds of things.
And then my second question was,
I'm afraid you're probably going to have to ask that because we're out of time, but I think maybe you can stay a few minutes.
Yeah, I did. He said to tell you guys like funny stories. I wanted to tell you about what may have happened during a trial or a hearing. We do preliminary hearings every other Tuesday in Houston County. And
we've got about 30 seconds.
Oh, 30 seconds. Okay, quickly. Had a guy who was charged with robbery by sudden snatching. He had supposedly driven through the parking lot of Kroger and snatched this lady's purse. We're having the preliminary hearing. I'm handling the preliminary hearing for the guy. The lady comes in. We've subpoenaed her. We've had the victim come in. She takes the stand, and when she takes the stand, she has a purse that clearly has fingerprint dust all over it. And so I'm crossing her about the purse and about the snatching, and the client leans over and says, "That is not the purse I snatched. The purse I snatched is white."
Join me in thanking you.